So my name's Frank Meilinger. I'm the communications director here at OSHA, and I have the pleasure of being the moderator for the sessions today. And I just want to welcome you and thank you for taking time out of your day to be with us. Today is the first day of 4 that are focused, that are part of our Workers' Memorial Day week, and it will ultimately culminate with our Workers' Memorial Day program, which is here in the Department of Labor building, but we'll be broadcasting it and streaming it as well. So that on Thursday at 1 o'clock Eastern time, we'll have our Worker Memorial Day program, and followed by our wreath laying ceremony. So if you're in the DMV and you would like to join us, you're more than welcome to. If you're not in the area but still want to be a part of the program, and you're more than welcome to. It's going to be streaming on our website here, so just click here or ask for the link for that. So to get things going, today's program is meant to the full day's program is meant to educate and provide insights into all the things, or many of the things that OSHA does for both employers, employees, and others that are interested in and involved in workplace safety. So if you're registered for this session, your registration will allow you to attend all the sessions today. So if you want to come in and come out and join us on occasion, or if you want to stick around with us the whole day, that's cool too. We would certainly welcome that. If you have a question for our next presenter, Prentice Cline, if you have a question for him, just please drop it here in the chat, and I will do my best to get to as many as I can. And with that, I'd like to introduce our next presenter, Prentice Cline, who is the director of the Office of General Industry Enforcement here at OSHA. So, Brent, I'm going to hand it off to you. Please welcome Prentice Cline, guys.
Thanks, Frank. You able to hear me okay?
Yes.
Okay.
We can hear you and see you.
All right. So, okay, thank you. And I want to thank Tanya Ford for her work organizing this and the invite to talk about the OSHA complaint process. As Frank said, I'm in the national office of OSHA in the Directorate of Enforcement Programs and General Industry Office. So one thing I wanted to echo here is that from Mr. Parker is that the OSHA Act gives workers rights, and filing a complaint with OSHA is a worker right, and it's important that workers understand that right and how to go about filing a complaint. So any time that a complaint's filed and processed, I can tell you it has the potential to have a lot of impact on worker safety. Generally, whether we do an inspection or something short of an inspection for complaints, just the mere interaction with our area offices with employers about specific issues raises awareness. It's an opportunity to have impact, and not only do we get specific issues fixed with complaint discussions with employers, we also have the opportunity and take that opportunity to make sure that there's a policy, a procedure, or training in place to prevent future occurrences that are the same. So these, the complaint process allows us to have a lot of impact, in my view, and workers, it's important that workers take the opportunity to exercise that right. So I have a PowerPoint. Tanya, are you able to get that loaded? Okay, great. All right, so let's talk first. Let's talk first. Is that okay? Can you hear me okay now? Good. All right. Let's talk first. Next slide, Tanya. Let's talk first about OSHA and are you covered by OSHA? We have to have OSHA coverage, jurisdictional coverage, in order for the agency to take action on a complaint. So if you're a private sector worker, OSHA generally is going to cover almost every private sector employer and workers in every state. Any place where there's an employer-employee relationship happening, even if there's only one employee, generally, unless we are preempted by another federal agency, we will have coverage. Now, that coverage may be either directly through the federal government, OSHA, or through an OSHA-approved state plan. If you're a state or a local government worker, those workers are not covered by federal OSHA. However, they do have some protections if they work in one of the states or U.S. territories that have an OSHA-approved state program. And there's a number of those. And then federal government workers have across the board federal OSHA protection. Okay, next slide. So this is just a map showing how that's laid out in the U.S. So you can see there's about 22 states that have approved state OSHA programs. Those would be the medium blue color, like Kentucky, Tennessee, Virginia, the Carolinas, etc. So in those states, the state government runs and administers the OSHA program for that jurisdiction. There's 7 other states that have a coverage only for state and local workers, and those are represented in the dark blue. And then the balance in the light blue are states that have no state OSHA program other than perhaps they have some consultation services, but the enforcement is handled through the federal government. Next slide. So what is a complaint? One of the things to talk about here today is how does OSHA look at these complaints, and how do we triage and think about them? A complaint basically is a notice to us, to OSHA, of an alleged hazard, and in order to be actionable by the agency, it has to be within our jurisdictional coverage. So the OSHA Act has to give us the ability to process it and take action on it. It needs to be reasonably specific so that the work area or task or equipment or the condition in question can be identified and reviewed, whether it's by an OSHA inspector or by the employer. And the condition described has to reasonably, have the potential to be a violation of the OSHA Act or an OSHA standard. So, in order to have what we would call a valid, actionable complaint, it has to at least meet those 3 criteria. Now, of course, that doesn't mean that your issue is invalid if we can't deal with it. It just means that we may need to get additional information from you as a complainant, or even put you with another agency if there's coverage issues. Next slide. So internally in our policy, we would classify two broad types of complaints that come into us. One we call formal, and the other we call non-formal. And our action taken is generally different for each of those. So I can cover each of those. Next slide. So a formal complaint that comes into us would be something from a current employee or a representative of current employee or employees that one describes or asserts that there's an imminent danger, a violation of the act, or a violation of a standard that poses a potential threat or harm to workers in the workplace, and it's reduced to writing, or it's submitted on DOL complaint form. So sometimes people will just handwrite a complaint, which the area office may tell them to do if they would like an inspection to be done. Or you can download from the OSHA website the complaint form, or you can fill it out electronically, which I'll show you the link for that. So reduced to writing or put on our complaint form, and then signed by at least one current employee or an authorized employee representative of a current employee. And an electronic signature, of course, is acceptable, and there's a method provided for that on our online complaint portal. So that's a formal complaint. In the next slide, I can talk about a non-formal complaint. So a non-formal complaint would not have those attributes. In other words, it's not signed off from a current employee. It may be from a recently separated employee. It may be a complaint that the employee declines to sign and wants to be considered anonymous even to OSHA. It may be information that comes from an associate or a family member of an employee. This would describe, or this would be the majority of complaints that are received by OSHA fall into the non-formal complaint category. Those generally are coming in by a telephone call to the area office, or an email sent to a compliance officer or to the agency's email box. Or they may be submitted through the agency e-complaint system, but not signed electronically. We also receive complaints via regular mail, obviously, and some of those as well will be anonymous and not signed. We want to take all those complaints and process them that we can. They need to be specific enough to identify an area, equipment, work task, etc., to allow either the government or the employer to do a reasonable review and inspection of the condition. So where we've got that kind of sufficient information, we would usually initiate what's called an inquiry with the employer. In some circumstances, we may initiate an inspection instead, even on a non-formal complaint, and there's some policy indicators for that, which I'll cover here in a moment. Next slide. So when I say an inquiry, what do I mean? So that's a complaint, how we're handling a complaint that doesn't meet the criteria for us to have the authority to go on site and do an inspection. So we will interact with the employer in another way. We will promptly, and when I say promptly, within one business day, notify the employer by telephone. So generally we have a telephone conversation with the management of the establishment about the items in the complaint, the alleged hazards, what the allegations are, and then we will email, or not much in this day and age, but we can fax that as well. Generally it's an email, a letter that confirms the discussion and provides specific instructions to the employer about what they need to do. It's going to advise them of what they need to do to answer that inquiry to OSHA. We require a response from the employer within 5 working days, and we expect a reasonably thorough investigation that would give a full report to us of their findings and abatement. If we get an inadequate response or no response, we have the right to go out and do an inspection of that. However this comes out, whether it's an inspection or a valid investigation and response from the employer, we advise the complainant, if we have their information, of what the outcome of this was and what the findings were and what action the employer took to rectify the hazard. The complainant has dispute rights. They have the right to respond to us and say, I disagree with the response from the employer and here's why. And generally, we're going to take action on those to inspect that facility if the information provided is credible from the complainant, that they have a reasonable underlying source of information that would dispute what the employer has represented to us. Next slide. So generally, an inspection can be done for any of these complaints where we have sufficient information that would lead us as a discretionary matter to take that action. Obviously, where a valid formal complaint is filed, that's the action generally that's taken as an on-site inspection. That's the purpose of a formal complaint and the signature. However, if the complaint comes into us and alleges credibly that there is an imminent danger situation, if they allege that an inadequate response has been taken to resolve an inquiry, if they allege that an employee under the age of 18 is working, or if there's hazards that are covered by local or regional or national emphasis programs, and there's some indication of the existence of injuries that have occurred, or if an injury is highly possible to occur, the agency does have the discretion at the area office level to go and do an inspection in any of these complaints. We do have to have some clear evidence that a serious violation may exist. We may apply that discretion as well if there's a history of non-compliance at this facility that where the alleged conditions are occurring. So with the overall goal of taking enough action to prevent these incidents before they occur, and that's really the purpose of the complaint process. Okay, next slide. So how do you file a complaint logistically? There is a web page on the OSHA website. You can see the web address at the bottom, where it's basically a portal that explains how to file a complaint. Essentially, you can use an online complaint form, which is linked here to submit your online complaint. And in that online system, you can simply check a box, yes or no, whether or not you want to electronically sign it. You can download a complaint form, which is the second item, and you can mail that, email it, or even fax it, or you can send a letter to the area office. In that case, you can as well sign off on those, and it will, in most cases, result in an on-site inspection. The majority of our complaints come in through telephone calls, and certainly can discuss any of these concerns for safety and health through a telephone conversation. And to the extent that an inspection is desired in those after a telephone conversation, we can advise you on how to do that, provide you with the proper form, and give you 5 days to send that back to us before we take any action. And then, of course, you're always welcome to visit your local OSHA area office. You can walk in and you can sit down with an OSHA staff member and explain and discuss your complaint. This works particularly well if you've got pictures, schematics, something that you want to lay out and have a discussion about. And we encourage you to do that. Next slide. So some tips for providing a complaint to OSHA to make sure that you get the outcome that we're all looking for. So that you can see here, this is a representation of the OSHA complaint form. The online, if you print it out, it looks just like this. There's fields for the establishment, the address, some contact information, basic information about the hazard, and the identity of the individual that's providing the information. We would encourage you to provide as much detailed information about the hazard or the condition as possible. The location, the frequency of exposure, how long has it been there, how long is somebody exposed, exactly what is the equipment, any specifics you have about it, because a compliance officer may be going into that facility trying to identify where this area and this equipment or this work condition exists. So you want to be able to lead them to it. Provide your contact information, because any additional follow-up information that we need to get at in order to process the complaint, we would have to reach back to you to be able to grab that. So next slide. Your identity and your personally identifying information are not released, and that's kept confidential. So that should not be something that you have a concern about. We have lots of policies that prevent us from releasing that information. So the OSHA whistleblower protection is a separate presentation I believe is coming up next. I want to just mention that often during the complaint process, workers have a concern about being discriminated against because they exercise their right under the Act to file a complaint, and that is not permitted by federal law. And you should contact OSHA as soon as you believe that you've been discriminated against for exercising those rights. And I encourage you to attend the next portion of this event to hear more about whistleblower protection and the rights that workers have. And with that, Frank, I'm finished and can take any questions.
Perfect timing, Brent. Thank you so much. How's that for perfect timing? And what a great segue, because Meghan Smith is our next presenter who will talk all about whistleblower protections and other pieces of that. Hey, Brent, can you please, there's one thing, I think we had a hand up, which everybody's muted. So if you could drop your question here in the chat, I'd be happy to get to it. The other thing, Brent, can you talk about timelines for filing a complaint?
So a complaint can be filed with us, preferably as soon after the exposure occurs as possible, so that we're able to get at it in a timely fashion in terms of evidence gathering. However, we have a 6-month statute of limitations on dealing with issues. So any hazard that has occurred within the last 6 months is something that we can investigate. We generally do those inspections for a complaint within 5 days.
Okay, great, thank you. And I think the key there was as soon as the hazard is identified. All right, thank you, Brent, very much. I think we're all set. So, what's that? There is a question? Okay, forgive me. I'm sorry. I got too many things. How can the labor liaison help in filing the complaint? Great question, by the way. Thank you, Nicole.
Sure. So, to the extent that a labor liaison has information that can be helpful for workers, we encourage them to have that interaction and provide, the mechanism for how they file a complaint, or they can be the conduit for that complaint and if they have a relationship with a worker or a worker group, union, etc., and there are hazards that they want to file a complaint with, we are happy to have that come through our labor liaison or any other conduit that can get that information to us.
Thank you very much, Brent. Hey, we have one more question, and this comes from Miriam, and she asks, we have a complaint that is closed. The employer is taking some steps to make the required changes, but we feel there are some components that are not being addressed properly. What are our options for next steps? And is there a window of time that the employer has to make these changes? Another great question, Miriam. Thank you.
Absolutely. So when a complaint is handled and they respond to OSHA, it's not uncommon that if it's a complex issue, they may have an ongoing time frame that's agreed to between OSHA and the employer to complete those abatement steps or fixing that hazard. They're supposed to be communicating that information by posting it for the workers. If the complaint has been closed out, quote unquote, by OSHA and by the employer, but there are still unfinished items there for abatement that is still providing exposure to a hazard for workers, the employees should contact their area office and have a conversation with the compliance officer and describe what those elements are that they believe have not been taken to the extent that they should be to remove the hazard. And it may be that we need to reopen that complaint and look at it again perhaps even with an inspection. They can certainly dispute that the complaint was legitimately completed.
Great, thank you, Brent. Just for everybody's awareness before we move into our next session, I just want to point out that there's a map on our website that lists all of our area offices, and so you can find an office that's very close to you. And I'll drop that here in the chat for everybody. So Brent, thanks so very much
Sure.
For your presentation. Really appreciate it, and I also really appreciate everybody staying with us and asking the great questions. They were really great questions. So thank you very much, everybody. Our next session will begin in just a minute here, and it's about whistleblowers. We'll see you soon. Okay. Okay. Good morning, everybody. My name is Frank Meilinger, and I am the communications director here at OSHA, and I'm also the moderator throughout the day here for all of our sessions. And thank you for joining us. Because you're here on this, your registration allows you to attend any of the sessions throughout the day. So join us when you can, or hang out with us all day long. You're more than welcome to do that. To keep us relatively on track, I just want to mention that real briefly that our chat line is open. So if you have a question for Meghan Smith, who is our next presenter, please put it in the chat, and I will gladly get to them, or as many as we can. Please do that. So it's a joy to introduce our next speaker, who is from our whistleblower Directorate, Meghan Smith. Meghan is incredibly passionate about whistleblower protections, and we're thrilled to have her here with us today. For those of you who may not be aware, we have more than 20 statutes that our whistleblower office and whistleblower investigators cover. So with that, I'd like to introduce to you Meghan Smith.
Thanks, Frank, for all those kind words. Good morning, everybody. And I also have some slides today. So Tanya, if you could throw those up there when you get a chance, that would be fantastic. So today, what we're going to talk about is how, when, and why to file a complaint with OSHA's Whistleblower Protection Program. Next slide, please. Most of you are probably familiar in some form or fashion with OSHA's safety enforcement. Filing a safety and health complaint with OSHA is different than filing a whistleblower complaint. Safety complaints involve unsafe or unhealthful conditions that you encounter at the worksite. OSHA only investigates potential safety and health violations under the Occupational Safety and Health Act, which we'll be referring to as the OSHA Act for the rest of the presentation. So whistleblower complaints are different. An employee can file a whistleblower complaint when they have been retaliated against for engaging in protected activity. What does this mean? For example, if a worker complained that their fall protection system was no longer in good repair and their boss fired them for reporting the fall protection issue, they could file a whistleblower complaint with OSHA for being fired. They could also file a safety complaint with OSHA to report that their former employer was requiring employees to use faulty fall protection systems. The last major difference between safety complaints and whistleblower complaints is that whistleblower complaints cannot be filed anonymously. And we'll talk more in depth about these whistleblower issues as we go along. Next slide, please. OSHA accepts whistleblower claims for investigation when they meet certain criteria. One important threshold issue, however, is that, except in rare circumstances, the whistleblower laws OSHA enforces only cover employees in the private sector, although United States Postal Service employees are also covered under the OSHA Act. The first criteria is, did the employee engage in protected activity? What this means is that the employee exercised their rights under one of the statutes enforced by OSHA. Currently, as Frank mentioned earlier, OSHA enforces the whistleblower provisions of 25 different statutes. And these statutes cover a wide variety of issues and industries, including employee safety, consumer product, motor vehicle, and food safety, environmental protection, fraud and financial issues, health insurance, and transportation services. Protected activity will be different depending on the statute at issue. Examples of protected activity include, for example, reporting to your employer that the brakes in your assigned commercial motor vehicle have failed, making it unsafe to drive, reporting to the Securities and Exchange Commission that your company committed wire fraud, reporting to the Federal Aviation Administration that the airline you work for allowed a plane to fly that had a safety issue related to a wing, reporting to your director that your nonprofit association is in danger of losing its nonprofit status because it's not following applicable tax laws, and reporting an on-the-job injury to your employer. These are just a few examples. There are many more types of protected activity that are covered under our different statutes. The next criteria is that the employer must take an adverse action against the employee for engaging in the protected activity. An adverse action is an action which would dissuade a reasonable employee from raising a concern about a possible violation or engaging in other related protected activity. Retaliation harms individual employees and can have a negative impact on overall employee morale. Because an adverse action can be subtle, such as excluding employees from important meetings, it may not always be easy to recognize. Adverse actions may include such actions as firing or laying off, demoting, denying overtime or promotion, disciplining, denying benefits, failing to hire or rehire, intimidation or harassment, making threats, reassignment to a less desirable position, or actions affecting prospects for promotion, such as excluding an employee from training meetings, reducing or changing pay or hours, more subtle actions, such as isolating, ostracizing, mocking, or falsely accusing the employee of poor performance, blacklisting, which is intentionally interfering with an employee's ability to obtain future employment, constructive discharge, which is quitting when an employer makes working conditions intolerable due to the employee's protected activity, or reporting or threatening to report an employee to the police or immigration authorities. The third criteria is that the employer, management, must have knowledge of the protected activity. For example, if you complain to a coworker that all of the emergency exits are blocked in violation of an OSHA standard, the employer has no actual knowledge that the employee made any kind of safety complaint. If the same employee said the same thing to their supervisor or their manager, however, that would show employer knowledge. It's also possible to show employer knowledge even when it's not direct. So let's say that an employee is the only employee who works in a plant who works on a particular machine. Let's also say there are only 10 workers in the plant. The machine is not properly guarded. If the employee makes a safety complaint to OSHA about the unguarded machine, the employer is likely to infer who made the complaint because it's a small workforce and only one person uses the machine that's complained about. The final criteria is what we call nexus. And what this means is that there has to be a connection between the protected activity and the adverse action. For example, if an employee complained about really high temperatures in a warehouse and was fired the next day, it may be likely that the termination was the result of the employee engaging in protected activity. However, imagine the same scenario, but that the employee was laid off the next day with 200 other employees as part of a long-planned reduction in force. In that case, it's just bad timing for the employee because the decision to lay him off would have been made prior to his complaint about the heat. Next slide, please. So when do we file? When should you file a whistleblower complaint? So as this slide shows, employees should file when they have engaged in protected activity, they've suffered an adverse action, and they believe the protected activity caused the employer to take the adverse action. And it's really important to note that OSHA can't open a whistleblower complaint until the employer has taken an actual adverse action against the complainant. But if the employer has committed any retaliatory act against an employee, the employee should file a whistleblower complaint. Next slide, please. So how to file? OSHA takes complaints from employees in any format and in any language. Typically, the best way to file a complaint is to use the online complaint form found at whistleblowers.gov. Complaints filed online are most quickly routed to the correct office for investigation. The online complaint form is also available in Spanish. OSHA has access to interpreters for employees who need to file complaints in languages other than English. Retaliation complaints are not required to be in writing, and complainants are not required to have representation. So you don't need a union official to represent you. You don't need an attorney. You can file on your own. Next slide, please. So when you file a whistleblower complaint, there's information that's very helpful for the agency to have, but none of it's required. The kind of documentation listed here helps our investigators investigate whistleblower cases. If a person is concerned that their manager may take a retaliatory action against them, they should make copies of all relevant documents prior to their termination, as they may be locked out of emails if they're terminated. So what are good things to have? Documentation regarding additional complaints, such as safety or health complaints or other statutorily protected complaints with OSHA or other enforcement agencies. Copies of any relevant lawfully obtained documents, the key there is lawfully obtained, such as emails, phone records, text messages, activity logs, memos, anything related to your complaint. Copies of hiring or termination letters, a copy of the employer's handbook, or if you're in a unionized workplace, your collective bargaining agreement. Copies of any disciplinary actions that you received during your employment, a current job description, a list of names and telephone numbers of potential witnesses who can confirm your allegations. And the key is people who can confirm the allegations and not just witnesses who may be a character witness for you. The names, titles, and contact information of management officials who made the personnel decision, and the same thing, names, titles, and contact information for individuals who processed the paperwork regarding the personnel decision at issue. And so typically this would be something like HR, human resources personnel. Copies of your last 5 pay stubs, copies of documents from any other proceedings between you and the company. So, for example, if you have previously filed a complaint with the Equal Employment Opportunity Commission, copies of that may be useful. And then copies of all documents from unemployment or workers' compensation proceedings that are related to the incident. Next slide, please. The 25 different whistleblower statutes that OSHA enforces have different filing deadlines, and these range from 30 days to 180 days. And employees should file as soon as possible after they've been retaliated against because of these tight timeframes. It is far better to submit a bare bones complaint quickly and then supplement it with additional information later. Complaints can always be amended if necessary, such as when new adverse actions are taken by the employer. For example, if someone files a complaint after they've been suspended and they're later fired by their employer, they can subsequently amend their complaint after they're terminated. There are some cases where OSHA may accept a complaint past the deadline, and we call this tolling, but this is rare. OSHA will almost always honor a complaint that was timely filed with the wrong agency, however. So, for example, let's say an employee files a complaint with the Wage and Hour Division 2 days after they're terminated, and after a conversation with the Wage and Hour investigator 2 months later, it's determined that the complaint properly belongs with OSHA instead. If the complainant promptly files with OSHA, showing they initially filed with the Wage and Hour Division, OSHA will investigate the complaint. Next slide, please. So how do we conduct these whistleblower investigations? Once an employee files a complaint, one of the regional investigators will contact them to conduct a screening interview. If an employee alleges the elements that we talked about earlier, namely protected activity, an adverse action, employer knowledge, and nexus, the thing that ties it together, the investigator will docket the case. At that point, they send out letters to the employee, who we call the complainant, and the employer, who we call the respondent. The respondent is asked to provide a position statement describing what happened. After that, the investigator gathers evidence. They conduct interviews, they ask for document requests, and so on. The employee will also provide a rebuttal statement or have a rebuttal interview at some point after the investigator receives the employer's position statement. After the investigator has gathered all of the evidence, they make a recommendation to their supervisor regarding whether the case has merit or not. At that point, the investigator will conduct a closing conference with the party receiving the unfavorable determination to explain why the agency made the determination that it did. Letters explaining the decision will be sent out to the complainant and the respondent, and then the agency will close the case. One last thing to note is that parties have the option to settle their complaints at any point with or without the help of OSHA personnel. Next slide, please. So OSHA's whistleblower program has its own website that's separate from osha.gov, although you can get there from osha.gov. It's whistleblowers with an s.gov. Whistleblower.gov was taken by a different federal agency, so if you're looking for OSHA, make sure you add the s at the end. And on our website, we have a wealth of information on each of the 25 statutes that we enforce, how to file complaints, how to create an effective anti-retaliation program, and lots of answers to whistleblower-related questions. And that concludes my prepared portion for today, so I'm happy to take any questions if there are any.
Thank you so much, Megan. That was really wonderful. If anybody does have questions, please drop it here in the chat, and I'll be happy to get that to Megan. Also, too, apparently I was reading your mind, and I put the whistleblower page URL in the chat here. Please take a look at that. And we do have a question Megan, is from Anna. What employees are not included, which I assume is like which employees are not protected by OSHA's whistleblower statutes?
Yeah, so that's a good question. So most of the time, federal employees are not covered by OSHA statutes. There are other statutes that cover federal employees. State employees are generally not covered by federal OSHA. However, the state plans all have their own version of Section 11C of the Occupational Safety and Health Act. And so states where there are state plans, their employees are covered under those plans. And there are some states where that are part of federal OSHA that have their own special provisions for their state employees. But basically, the employees that are covered, it depends on the specific statute that we're talking about. So there's a lot of it depends as part of that answer.
I think we need a flow chart, Megan.
Probably. We always need a flow chart.
Right?
Yeah.
Hey, Megan, can I ask you a question? And again, I encourage folks to ask questions of Megan, because we do have a few more minutes left. But Megan, how long does a typical whistleblower case take? I know you went through the steps of it, but how long does that take?
There's really no typical case, unfortunately. So it really depends on the region that it's in, sort of the regions all have like a little bit of a backlog. So it depends on that. It depends on how complicated the case is. Sometimes more than one employee may suffer an adverse action at the same time. So if you've got multiple complainants, there are a lot of moving pieces. And so it depends on how complex or how not complex the case is, how many witnesses there are, how many documents to look at. But always the fastest way to resolve a case is through is when it's settled, either with the help of OSHA or without the help of OSHA. And typically that's the way that if someone is going to find relief for their complaint, typically, settlement's going to be the fastest and easiest way to do that. Of course, we are always happy to conduct a full investigation.
Great. Thank you so much, Megan. Hey, Megan, I just have one more question for you. And
Yeah.
Well, I could ask questions all day long, but I won't. But the question I have is confidentiality. I know that this is a big issue for people who file whistleblower complaints. Can you talk a little bit about what's confidential, when it's confidential, and what's not confidential?
Absolutely. So when you file a whistleblower complaint and we docket it, your employer will know. You can't file an anonymous whistleblower complaint. The one thing that we keep confidential to the extent that we possibly can is non-management interviews. So if we're investigating a case and we have to talk to your coworker, if they request confidentiality, we will keep that confidential to the fullest extent that we possibly can. And so because we want people to be able to come talk to us, we want to, figure out what's going on at these workplaces. So that's generally the extent of confidentiality with us.
Great. Thank you, Megan. We have a couple more questions. What do you have a sense for what's the percent of cases that are settled?
I know we have that. We have that information somewhere. I haven't looked at that statistic for a while, so I hesitate to say anything because I don't want to say the wrong number. So the answer is I can see if we can figure that out, but I don't know the number off the top of my head. Is unfortunately
that's fair.
Short answer. Yeah,
I appreciate it. Just trying to find one nugget of data in all.
I know. I'm not the data person, and there's a reason. So yeah.
No, I get it. Thanks.
Yeah.
I'll tell you what we'll do. Megan, if we could follow up, I'll drop this back in the chat.
Yeah, sure.
When we have that number, and just keep in mind that things fluctuate. Maybe not much, but they do. All right, one more question for you. When an employee is basically stressed to the point of where you want to quit, is that something that can be reported? And is there a time frame if there is an avenue?
That's kind of a two-part question. So the first part is what the question is describing is what we call constructive discharge. And so that's a legal term and so what that means is the employer has made the condition so intolerable for you that any reasonable person would be forced to quit in those circumstances. So it is admittedly a high bar, but there have been a few cases where even the courts have found that yes, the employer made things so intolerable that they were trying to get you to quit. And the time frames on that, so the time frame starts running the day that you quit. And so if we're looking at the Occupational Safety and Health Act, you would have to file within 30 days of quitting. So, and then for the other statutes, it depends on whatever other statute you are filing under. So that's the answer to that question.
That was a great question, by the way.
Yep.
So thank you for that. That was a really great question and a great answer, Megan. Thanks a million. Okay, we have 2 minutes left. So I'm going to give everybody one more opportunity to ask a question. But in the meantime, I just want to say that I invite everybody to join us all week long. Tomorrow we have virtual panels. We'll hear from family members, and we'll hear from workers' comp, and a bunch of other people. And Tanya Ford will be moderating the day, and so please join us tomorrow. And also too, we have Wednesday we have our first ever expo here in the Department of Labor building in DC. So thank you, Christine. The settlement rate is 24%, Mike, and that's in the chat. So thank you, Christine. So Wednesday we have our first ever expo, and on Thursday we have our Workers' Memorial Day program and wreath laying ceremony. So if you're in the DMV and you'd like to join us, we welcome you to join us one or both days. Want to do that. Our next session, which is going to begin at 12:05 Eastern Time, is with Marcus Smith, and he is an investigator with our sister agency, the Mine Safety and Health Administration. So I have a quick question. Is there a person such as Megan that we can reach out to with questions? And I hand this off to you, Megan.
So I guess what I would recommend that people do is we have an email box that we monitor. And you know what? I'm just going to put it in the chat. So if anybody has a question, they can send it to osha.dwpp@dol.gov. And I'm going to throw that in the chat. Yeah. And so if you have any follow-up questions, that box is monitored every day. In fact, today our usual person's not here, so I actually offered to monitor the box today. So you can always send questions there, and somebody will get back to you.
Okay. Thank you very much, Megan.